As you know, this lecture was going to focus on visual proof, visual evidence. And this will give you a little outline of why visual evidence is so important. The latest statement of authority about the retention of information, which is learning. Whatever, you don't learn anything unless you are retaining the information. The latest statement of authority about that came from a study by the U.S. Department of Labor in 1996, and here is the figure that they came up with. 83% of human learning, retained information, as I told you, occurs visually, and only the remaining 17% through the other senses, meaning mostly auditory. And this is really nothing new, I hope, to most people. The earliest statement of authority, for the earliest statement, we're going to go all the way back to that legendary Chinese philosopher Confucius. And he said, as I think most of you know by now, a picture is worth 1,000 words. And as a trial lawyer, I would have to endorse that completely. And now the purpose of visual evidence is to put it to use during a trial. You want to present it, evidence, as much evidence as you can, in the form of graphics, because graphics are vivid, and evidence that's vivid will be easier, always easier for the judge and the jury to grasp, because they use their visual perception. And they can recall it much more easily later at decision time, which for most of you will mean the verdict that comes at the end of the case. So now you've got the introduction to why I think, and most trial lawyers today think, that visual evidence or graphics is so important when it comes to proving the case and convincing a jury that your client deserves to be compensated. Graphics or visual evidence has been around for a long time, but mostly in a static form. And now I will review some of the forms of visual evidence or graphics that I myself have used in trials, and you'll see the value that this kind of evidence has in a case. First, we're going to look at a photo projection of a picture of a house, and I put the title on it of The House That Won a Case. Now, that title did not appear on the picture of the house when I presented it in evidence. That title is really for your benefit. And the way it won a case was in a very surprising manner. And if somebody told me that this is how it happened, I would have a hard time believing it. But it happened to me. So I'll tell you more. I'll tell you more about how this house won a case. The woman who owned the house asked her brother to come over and help to remove snow, a lot of snow that accumulated. This house was located someplace in Queens. I think you can see the snow on the lower roof of the house. Much more snow accumulated in the back of the house, in the backyard, in fact. So the woman who owned the house asked her brother to come over and shovel the snow out. While he was in back there, a tree, an overhanging tree from the neighbor's yard, fell down, and the branches knocked him unconscious. So there he was laying there in the yard, unconscious, and suffering a serious injury. And finally somebody came across him, probably his sister, although I don't remember, and they had to call the fire department in order to remove the branches and take him to the hospital for treatment. So so of course we claimed that the neighbor was at fault because the tree in his yard constituted a hazard, and therefore he was negligent for allowing this tree to grow and to continue to remain there in a hazardous manner, to continue to pose a hazard. The defendant's lawyer came up with a very good argument against that. He said that at or about the time that this tree fell over the fence, the wind in that area was gusting up to 50 miles an hour, which is a very, very high wind. And he got that data from the records at the Kennedy Airport. So this seemed to be a very strong argument in order to avoid the imposition of liability on the owner of the adjoining house and the tree. However, fortunately for our side, the jury came back with a verdict for my client. They found that the neighbor was negligent, and that was the cause of the accident. Was negligent in allowing the tree to continue to grow in that kind of manner. The defendant's lawyer was very puzzled by the verdict. He thought he had a surefire defense. So he wanted to talk to the jury after they were discharged, after they gave their verdict and discharged. And lawyers are allowed to do that, by the way. It's something I usually don't do, but in this case I felt I should go along with the other lawyer and find out what the jurors had to say. So one person spoke for the jurors, and he said that, and I'm trying to get to repeat it as accurately as I could. He said that the photo, this innocuous, ordinary photo, convinced the jury that my client's sister kept a neat house and a neat yard. Therefore, they reasoned from that my client's sister could not be blamed for the falling tree, but rather that the defendant neighbor was to blame because he did not keep such a neat house and a neat yard. That's what they said. Nothing at all about whether the neighbor had adequate notice that the tree posed a hazard. Nothing at all about whether they believed the wind was blowing at 50 miles an hour. They based their verdict almost entirely on the photo of this house and what they themselves extrapolated from it. Something that I think most of us would probably, or most trial lawyers would probably never expect. But it just goes to show, among other things, the value of using graphics as evidence if it can in any way be construed in favor of your client. Because this photo, as you can tell from what I've told you, left a very strong impression with that jury. I don't think that we could have done anywhere nearly as well if the woman who owned the house herself came up and tried to insist to the jury that she kept a very neat house and a neat yard, and therefore the accident was the neighbor's fault. I think that would have just gone by the jury and been brushed off by her as an effort, by them, as an effort to help her brother win the case. But you can't argue with a photo. And there it is. And fortunately, the jury drew a very favorable inference for us from the photo, one that I never expected. Another way to use a graphic evidence, and by this I mean static graphic evidence. We're going to get into animated or active graphic evidence later when I talk to you about PowerPoint in conjunction with a computer. The PowerPoint program, which I'm sure most of you have heard about, even if you haven't used it. Well, I hope most of you have heard about it. Anyway, you can always enhance the value of graphic evidence, visual evidence, if the client himself, who is a witness, is able to testify with the assistance of some kind of graphic. Because then you have the client's testimony reinforcing the graphic evidence. And it also makes the client's testimony much more credible, because he or she is up there pointing to something that is indisputable, because it's a photograph or some kind of record of a scene. And I'll show you what I mean. Next slide, Gregory. There in the background, you can see me. That photo was taken many years ago. The young man wearing a motorcycle jacket was injured when he was driving his motorcycle on East 86th Street in Manhattan. Now, going back to that period of time, before the era of biking, before biking became so popular, the common concept of anybody who would drive a motorcycle in New York City traffic is that he must be half crazy. However, we had to overcome that. We had to overcome that kind of preconception that most jurors would have. And the way we did overcome it is by having the plaintiff testify in conjunction with this graphic. And this graphic was a enlarged scene of the traffic on East 86th Street in Manhattan. At the top of it, this part would be the traffic going westbound. See, this is the traffic going westbound. This is the traffic going eastbound. And he's pointing to a place. He's pointing to a place where, while he was on his motorcycle, traveling properly in an eastbound direction, the car in front of him decided to make a U-turn in order to go westbound. And naturally, the crash ensued between his motorcycle and the car that was making the U-turn. And this was very convincing, especially because he was very well prepared in the way he could discuss the scene that was on that graphic. I can't emphasize that really enough, that if you're going to use a graphic in conjunction with your client's testimony, make sure that your client is in total command of that graphic, that he knows exactly what it represents, what every part of it signifies, and that he can speak convincingly and persuasively about everything in the graphic. But anyway, this plaintiff, this witness, was so good that we were able to settle the case for the full amount of the insurance policy, which is quite a feat when you consider the kind of attitude that jurors had toward motorcyclists in those days. Now, another important feature about graphics as evidence is that you can use a color graphic to tell a story, or color graphic to represent certain facts. And that's going to make an even stronger impression than a black, white, and gray graphic, because the colors leave a strong impression in people's minds. And I'll show you what I mean by the next graphic. Next slide. Once again, I have to caution you, don't think that this title appeared on the graphic. This is only to describe the purpose of the graphic to you, or the value of the graphic to you. If I put this on the graphic in court, it would have destroyed my case. Now, what this case involved is a woman who was a nurse. She was a floor nurse at a certain hospital, some hospital in New York City. And she had been looking at houses. She wanted to move. And one of these particular houses, as she was walking through the driveway area, the owner of the house decided to drive into the driveway, into the garage, and clipped her as he drove into the garage. Hit her in the knee and caused her to lose a great deal of time from work. Because of the time that she lost from work, she lost her job. And she had to spend quite some time looking for a new job. Now, we had an economist who testified at the trial, and this chart really reflects the figures in the report of the economist. And according to his analysis, this is the amount of money she would continue to earn from the new job that she had obtained. After several months, she did obtain a new job. And his analysis was that she was going to earn money, her annual salary would continue along these lines. But he also stated that on her prior job, she would have continued to earn a salary that would be reflected in these figures, see? And therefore, the difference between the income from her new job and her old job was the amount of money that she lost and would continue to lose due to the accident. This chart had an unintended effect, but that was very beneficial for us. It really bedazzled the attorney for the defendant because he overlooked one very important fact, which is that in the new job was actually a promotion over her prior job. As I said, in her prior job she was a floor nurse, but in the new job she became a nursing supervisor. She was in charge of floor nurses at the new hospital. So this chart really, I would say, was open to question. And I mean, the figures were open to question. The figures that the economists presented were open to question. But the defendant's lawyer was not adept enough to see through that. As I said, I think that he just sort of got mesmerized or confused by the colors that he saw there and couldn't really separate the meaning of the various colors in the chart, which was lucky for us because while the jury went out to deliberate, the defendant offered to settle the case for about $165,000, which is not the figure then, but it's adjusted for inflation. And the woman who had become a nursing supervisor was elated over that and glad to accept it as the settlement figure. One more type of graphic that was also common in the pre-computer age, which was sort of a bridge into the computer age, and that was the use of film. The use of film, or today they call it videos. Videos were good because they showed somebody doing something that would be favorable, hopefully favorable for your case. And it tended to capture people's attention much more than a static graphic. So let me show you a film or a video that I used for a very good result. Let's go to the next slide. Once again, that is a dramatic title that I put on for this video, and I'll tell you why it's accurate. The woman in the blue dress was the plaintiff, and her name was Rose Hansen, and she was a teacher at the Washington Irving High School, an English teacher at Washington Irving High School here in Manhattan. Then one day she was involved, or really the victim of a freakish accident which would probably never, ever happen again. Once again, I would say hard to believe for me if I was not involved in the case myself. She stayed late one day in her office on the 4th floor to mark papers for her English class. And then she wanted to step out of her office to go to the ladies' room. So she headed to the ladies' room, but unbeknownst to her, that same day, the girls' track team in Washington Irving High School was doing its practice sprints inside the school because of inclement weather outside the school. And also unbeknownst to her, they were doing their sprints on the 4th floor. So as she rounded a corner on the 4th floor on the way to the ladies' room, 2 girls who were on the track team crashed into her while doing their sprint. And the crash knocked her to the floor and consequently caused a fractured hip. And she was unable to ever return to teaching again in Washington Irving High School or any place else. She retired after that. Of course, the lawsuit was brought in order to recover damages for the pain and suffering for the fractured hip and loss of income because she was forced to retire from her teaching job. However, during the waiting period for the case to come to trial, Rose Hansen died of unrelated causes. It had nothing to do with the fractured hip. So there we were, coming to trial, without a witness who could tell the jury about the suffering, the pain and suffering, and whatever other deprivation the fractured hip caused her in her life. We just had nobody else who could fill that role. And that's vital, really vital in a personal injury case, because you've got to get the jury to make a comparison between the plaintiff's physical condition before the accident or injury and after the accident and injury. And that's the way they determine the amount of pain and suffering and how much damages to award. Now, the defendant, in this case, the City of New York, was aware, of course, that we did not have Rose Hansen or anybody who could talk about her physical activities. So they made what was considered to be a very conservative offer. They offered $50,000 to settle the case. Her brother, Rose Hansen's brother, was dissatisfied with that. He was the executor of her estate. And so I told him to try and think about any evidence that he might have on hand, anything that he might have stored away that would enable me to show how healthy Rose Hansen was before this accident. And he came up with this video. It was a video of Ms. Hansen dancing at her nephew's bar mitzvah, the nephew being the son of the brother who was the executor of her estate. So at the trial, I played this video in order to show how healthy Rose Hansen had been prior to the accident. Play the video now. Actually, I did run into opposition from defendant's lawyer. He objected to me putting the video into evidence. But the judge ruled in my favor. The judge said it will give the jury a basis of comparison. It will show the jury exactly, or generally, how well off, how healthy and active Rose Hansen was prior to the accident. And they can compare that to how the accident, the fractured hip, limited her movements afterward. And for that for that evidence, we had a doctor, of course, who came in and testified about the nature of the fracture to her hip and how it impaired her movements from then on for the rest of her life. Once again, that testimony otherwise, or in addition, would have come from Rose Hansen if she had been still alive. But the video, which gave us a basis of comparison to the jury, was very, very important. I would say it was crucial. I would really say it was crucial. I don't think that we could have convinced the jury that Rose Hansen was such a healthy and energetic person unless we had something like this to show them. And it served its purpose because after the video went into evidence and after the summations to the jury, the City of New York decided to raise the settlement figure from $50,000 to $200,000, which is a nice increase. And Ms. Hansen's brother, who I told you was the executor, was satisfied with that. He accepted it, and that was the end of the case. So this should convince you that videos or films can be very effective, to show the before phase of a person's life, when that person is claiming that he or she has been impaired, somehow impaired from continuing their life in the normal manner due to some kind of an accident or injury. And It doesn't have to be a video of somebody dancing. But you've got to probe your client or your client's family and find out what possible videos they may have of the client. It can show the person playing a musical instrument, or riding a bike, or fooling around at the beach. Anything that would demonstrate to the jury that the person was healthy and active and was able to enjoy life before they happened to be injured in an accident or in some other manner. And as the old saying goes, the camera doesn't lie. Nobody could dispute that this is the kind of activity Rose Hansen could engage in before the accident. All right, now we're going to come to more modern use of graphics, meaning by relying on the computer and the computer programs. In particular, the program I'm talking about, as I said before, is PowerPoint. Now, why are modern graphics better than the earlier graphics that I've just covered? When I say modern graphics, I mean graphics that you'll see on a big screen. Actually, you've seen these graphics on a big screen because they're being projected by a computer, and because they're all PowerPoint slides. They're all PowerPoint slides, so you have the benefit of being able to see them on a big screen. This kind of a projection was not what we had in the Rose Hansen case. There, we showed it on the screen of a DVD player because when I tried that case, when I tried this case, the court was not equipped to handle PowerPoint projections on a big screen. And these kind of screens were not available. But now we've progressed to the computer era and the big screen era. And this is important because these days people are used to processing their information from what they see on a big screen and of a television set or from their own computers. They've become used to relying on that as a source of information. And that makes them more comfortable because it's easy for them to handle. And it's become habitual. So you should try, if at all possible, to use a computer program, PowerPoint in my experience, in order to put images onto a big screen in court, which will be more convincing to the jury than if you're just using oral testimony. Now, another advantage, and in this day and age, by the way, you have that big screen available in the courtrooms of every courtroom in New York City. Or you can at least request that the screen be provided for the trial, because they don't put a screen in every courtroom because they don't have that many to go around, but they have them stored in the courthouse. So you can request at the start of a trial that the court provide a big screen, and then you can proceed and use your computer in order to project slides onto that screen. That covers the procedural element of the use of the big screen because of the comfort value that it provides to people who are watching it. But how about the content of the slides that you put on the big screen? You've seen the value of static graphics, I should say, you've seen the value of static graphics in 3 cases that I discussed with you. Well, the Rose Hansen case was not really static, that was film. But the drawback of those kind of graphics is that you have to rely on what somebody gives you. You have to rely on information or reports that you receive from other people. You don't have the means or the ability to alter the content and present it in a more effective manner. In Rose Hanson's case, for instance, in that nurse's case, what I relied on was the report of The Economist. And I had to stick with that report and present the figures just as they came to me in the report and put them onto the chart. In Rose Hanson's case, we were lucky because we had a video showing her doing something that was very active. But her brother could have just as well said, well, I can give you a video, it'll show you Rose Hanson eating dinner with us during my son's bar mitzvah. Which would have certainly shown something about Rose Hanson, but it would not convince the jury that she was as energetic and as active as she appeared to be when she was doing that dance at the party, at at her nephew's bar mitzvah. So you're very much, how should I put it? Dependent. That's the word. You're very much dependent on what you get from your other sources, for the kind of evidence that you can present. Even if it's graphic evidence, you're still dependent on what other people bring to you. One difference, and the major difference with PowerPoint or some other computer program that may be as good or better, but I've been used to PowerPoint, is that you can shape the evidence. You can shape the facts to tell a story by means of the computer program. And I'll show you how I did that in the case of James Brown against the City of New York. Firstly, I had to set the scene of events in this case for the jury. And this case involved an intentional tort, not an accident itself. It involved the claim of police brutality. So firstly, I had to set the scene by showing what led up to the claim of police brutality against James Brown. So to do that, I used a street map to show how Mr. Brown got to where the assault on him occurred. Let's go to that street map. Now, of course, Mr. Brown could have testified about the names of the streets and how he got there and what happened when he got there, but that would have just been throwing a lot of street names out at the jury. And they would remember some names and they would forget other names, but it wouldn't make much of an impression. It wouldn't really count for much. So instead, I set the scene by using this slide in PowerPoint. Once again, I had the benefit of the big screen in court. This trial took place in the Supreme Court of Bronx County. Judge Alexander W. Hunter presiding. In my opening, I told the jury that James Brown and his daughter, a 7-year-old daughter, got into a gypsy cab here at this station after they came back from a visit to a family member in Virginia. They got into the cab here, and along with other passengers, and they told the driver to take them to James Brown's home, which was what they expected to do. They traveled a while on this avenue and then turned off on Bruckner Boulevard, and then came to Boynton Avenue, where Mr. Brown lived. And the cab made a right turn to take him to his home on Bruckner Avenue, or on Boynton Avenue, I'm sorry, on Boynton Avenue. And it was supposed to stop right about over here, but it didn't. Because the driver of the gypsy cab saw a police car following him. And so the driver didn't bother to stop. Instead, the driver speeded up and then made a right turn on Lafayette and made a right turn on Colgate. All this time, James Brown was saying, "Stop, stop, stop, you passed where I live." But the driver didn't care because he wanted to get away from the cops. Anyway, because of the driver's haste in trying to flee from the police car, he didn't pay attention to traffic on Story Avenue, so as the driver of the gypsy cab was speeding up Colgate, he crashed into another car on Story Avenue. And then the driver got out of the car and tried to flee on foot, but eventually the police apprehended him. Then the police came up to the scene of the crash, and they forcibly removed everybody from the gypsy cab. They told everybody to get out, and they pulled James Brown out. And they, of course, they were much more gentle with his daughter, his 7-year-old daughter. Then they proceeded to interrogate the people who were in the cab, because they were suspects in the theft of the cab. And the way that they interrogated James Brown, according to his story, at this point here, was to force him to kneel on the ground and bend one hand behind the back, with one officer clubbing him in the back while asking him questions, which you're not supposed to do. Of course, later on, the police officer denied that he ever did anything like that. The cops went on to finish their investigation. After that, they took James Brown and the other passengers to the nearest precinct and put them in jail. So I relied on this PowerPoint slide to set the scene in my opening, to tell the jury what we were going to prove about how the police assaulted James Brown and about the injuries that they caused to him, particularly in his knee. The adversary once again objected. He said something like, "That's not an evidence, so you can't present it, you can't rely on it during an opening." And I said something like, "It doesn't have to be, because this is for the benefit of the jury." And Judge Hunter agreed with me that it would help the jury to understand better the proof that was going to follow. See, so it didn't have to be an evidence in order for me to refer to it. It was just a matter really for the jury's benefit to set the scene. However, later on in the case, when James Brown testified, and he himself described the route of the gypsy cab and what ensued afterwards when the police were chasing it and the crash occurred. At that point, I did offer it into evidence in a different form, because you can't put a screen like this into evidence. I had a pasteboard of the scene made up, and I offered that into evidence, and at that point, see, pasteboard. Okay. At that point, it was accepted into evidence because James Brown himself had stated all the facts about the travel by the gypsy cab and how the crash over here ensued and the beating that came afterwards. All right, but even from this, I think that you'll agree that looking at the scene on the screen gives you a much clearer understanding or visualization of the area and how the events transpire there than you would get from just looking at a pasteboard. This has, I believe, a much stronger visual impact. And it also is consistent with the way people process information by getting it from their big screen television or from their computer screens. You're just, in a sense, giving them more of the same. And you're making them feel more comfortable when they are receiving the information. Now, that was only a small part, a small instance of the way I used PowerPoint in the James Brown case. Most of the value of PowerPoint came from proving what's called special damages in a personal injury case. Special damages consists of two things. Consists of the cost of treatment that the plaintiff needed due to the injury, and it consists of lost earnings, the amount of income that the plaintiff lost because of the time that the injury prevented him from working at his or her occupation. And in this way, in these two areas, I believe PowerPoint told a very convincing story. I told you before that colors can tell a story. Well, numbers can also tell a story. Numbers can tell a story provided that you present them in a way that's easy to understand and to assimilate. And I believe that only the computer can do that with a program like PowerPoint. So, first of all, we wanted to show the cost of treatment to James Brown for the beating that he claimed the police inflicted on him. And in order to do that, I had to prepare James Brown to testify about each aspect of treatment. And treatment for him covered psychological therapy after the police beating, and it also covered 4 different surgical operations. So we had to discuss each one of these in order to make James Brown comfortable when he would testify about it in court. And to do that, I relied also on PowerPoint by using what I called prep slides. I would prepare a particular slide for each form of treatment. All right, this is the prep slide that I used in the office when I prepared James Brown to testify. This is all about the cost of psychological therapy, because getting beaten up by a cop was quite a shock to him, and I still don't think he's over it. And I don't think most people could get over it in their lifetime. Especially when one 7-year-old daughter is there watching everything take place, watching the beating take place. So you'll see that I divided the treatment into different categories. And also, I set up a column on the right side for the method of calculation, because James Brown would have to testify about how he reached the figure, about how he knew the figure was $24,000, or any figure. That's something that the plaintiff has to be able to explain, that to the jury. You can't just throw a number at them and say that's the number. You have to tell them how you arrived at that number. And you better be sure about how you arrived at the number, because that's fertile ground for cross-examination. That's where the adversary will try to trip up a witness by trying to show that these numbers were drummed into a plaintiff's head by his lawyer, and that the witness is just parroting what a lawyer told him. So these prep slides are very important because they enabled James Brown to focus on the cost of each particular form of treatment and be able to explain how he arrived at that cost. So this was the first prep slide, because the psychological treatment came first. Let's go to the second prep slide. Okay, this was the prep slide for, I told you he had if I didn't tell you, I should have, he sustained because of the beating when he was forced to kneel on the ground and getting pounded in the back by the cop, as James Brown said, and the cop denied. He sustained a very serious injury to his right knee. And first form of treatment that he got for that was an arthroscopy. And you see the date of the surgery up there, and the various items of cost. And once again in the right column, the method of calculation, so that James Brown could be very precise about how he arrived at each of these figures. And then you get the total. All right, let's go to the next prep slide. The first arthroscopy, as you probably can tell because we're going to a second one, didn't help much. His knee still caused a lot of pain and caused him to lose time from work. So he went for a second operation, an arthroscopy, and this is the data for the second operation. Also, this is, remember, this is only a prep slide. This did not go into evidence because the commentary and the method source of calculation is not evidence. It's really support, a form of, how can I put it, reminders for myself and for James Brown as to how he can explain each of the figures for the damages, hospital costs, physician's costs, and prescription costs. And as you see, the explanation varies from each particular kind of cost. One is calculated from insurance records, the other is calculated from plaintiff's own records, etc. And there's a little summary as to tell you what period was covered by the particular cost. See, the difference being the hospital cost is just the charge on the date of the procedure, but the physician's cost extended beyond the date of the procedure, and they included follow-up charges as well. See? All right. Let's go to the next prep slide. James Brown needed even more treatment, so we had a third arthroscopy. And once again, you see the various costs for each part of that procedure, and you also see the way James Brown was able to arrive at the cost that was involved. As for this total knee replacement, that amount had to come from someone else because James Brown was not qualified to predict what a knee replacement would cost or even to say that he would need a knee replacement. That procedure was going to be sometime in the future. But we could present that kind of evidence from the doctor who was going to perform the knee replacement. His name was Dr. Harwin, and I'll tell you about his testimony a little later. We also relied on PowerPoint for slides to present his testimony. And he made very good use of those slides by giving sort of a mini lecture to the jury about what they showed. We'll go into that a little later. So James Brown could only testify with regard to the costs that he had already incurred in the past, because he knows what these treatments cost him from his records. Of course, he doesn't remember everything in his mind. Nobody could remember all those numbers. Well, I wouldn't say nobody. I'll admit that I couldn't. So James Brown, as a plaintiff, can testify about costs that he has already incurred, but he can't project into the future because he's not qualified to know what kind of cost future medical treatment is going to amount to. And as I said before, for that you have to rely on a medical witness, which we did. All right, but anyway, once we went over all of these various costs, at that point James Brown could testify about them with certainty in court. And as he testified about each particular treatment, and the evidence went into the record, his answers went into the record and became evidence, then I could use PowerPoint in another way. Then I used PowerPoint to tell the story. I used PowerPoint to tell the story by projecting a row across a chart showing the costs that that James Brown had already told about. This is very hard to visualize, so I'm going to show you exactly what I mean. Let's go to the chart. See, we prepared this cumulative chart showing consequential special damages for treatment services. And here you see three columns that you saw in the prep slides: the hospital costs, physician's costs, prescription drugs. Of course, there's no method of calculation there because that's not evidence. And after James Brown testified about the first item of treatment, which was psychological counseling, at that point I signaled my assistant to put the first row up onto the chart. And you see it here. You see here a summary of the various costs and data about the therapy and what when it started and what it was about. Then James Brown went on to testify about the second item of treatment, which was the arthroscopy, first arthroscopy. And after he testified, at that point, it was in evidence, and I signaled my assistant to project the second row. See? And here you have the figures that came right out of those prep slides. Remember? They were in the prep slide. Well, you don't remember, but if you want to see the prep slide again, I'll show it to you. So these figures were all in the prep slides. And so forth and so on until we filled up the entire chart. But each time I had to wait, or I had to elicit the testimony from James Brown as to the cost of the treatment before I could project the row onto the screen. Go ahead and do that now for the other procedures. So we stopped there. We've used up all of the treatments that James Brown had received up to that point. The value of this is that the jury actually sees where each of these numbers comes from. And then we were ready to put in a total figure. So at that point, we could demonstrate to the jury that James Brown treatment had accumulated, the cost of his treatment had come to something over $97,000. You may recall that I showed you a slide for a pending knee replacement. Later on, when Dr. Harwin testified, we were able to insert the row for that knee replacement and increase the value of the total cost for James Brown treatment. We'll get to that again when I talk about Dr. Harwin's testimony. Now the other element of special damages in a personal injury trial is the what I call lost earnings. The amount of income that a plaintiff or plaintiffs lost because they were caused to miss time from their normal occupation. They were caused to stay out of work and miss earning money from their normal occupation. So I presented this kind of evidence to the jury in the same way that I presented the evidence about the cost of treatment, which means that I used a chart for it. Let me show you the final chart, the final lost earnings chart that we presented to the jury, and then I'll show you the components of it. All right, see, that is the way we ended up with the lost earnings chart. But it was not shown to the jury right away in that form, because they would never be able to assimilate it. That's what I think you call these days information overload. Is that the right term? Yeah. Okay. What we did was we constructed this chart row by row, just as in front of the jury, by the way, just as I had constructed the cost of treatment chart. But there was one wrinkle to this, because James Brown had 3 different jobs that he held following the beating by the police. Of course, he had his full-time day job, or really he worked at night actually, for the MTA as a subway car cleaner. But he also worked part-time for a firm called Cambridge Office Services. You see Cambridge up there. And subsequently, Cambridge was taken over by Bound Business Solution. So then he worked for a certain period of time, part-time, for Bound Business Solutions. So that's how, those are the components, those are the separate components of this chart. So I'll show you the prep slides that I used to prepare this particular chart. First, we have to have a separate prep slide for each of the employers, one for MTA. Let's go into the MTA prep slide. Now this shows the different periods of time that he lost due to each of the treatments that he received, including starting with the psychological treatment. And you have a row showing the period of time that he lost and the amount of income that he lost during that period of time. And this relates only to the MTA. And it covers 5 different periods of time that Mr. Brown lost because of, initially, way back because of the beating, but subsequently because of the treatment time and how it forced him to stay out of work, to recuperate. And of course, there's my method and source column in order to make sure that James Brown would be able to present or to state the figures exactly, down to the cent, exactly for the amount of money that he lost. So that covered the lost earnings periods for MTA. Then I had a separate prep slide for the lost earnings figure due to the lost time from Cambridge Office Services. And you'll see that he lost income from working for Cambridge in 2 of the periods, only 2 of the 5 periods of his recovery, of the time he needed to recover from treatment. And once again, the amounts of money that he lost is presented down to the penny, and you see the reason for it because of how we were able to arrive at the exact sums. When you get to the 4th and 5th periods for recovery, they don't apply anymore because in the 4th period, during the 4th period, James Brown was working for Bound Business Solutions, which had absorbed Cambridge. There was no more Cambridge. And the 5th period, he had no part-time job at all because his knee continued to cause him a lot of severe pain. All right, let's show the Bound prep slide. You see, the Bound prep slide only shows lost earnings for the 4th period of recovery from treatment. All right. Now, having prepared James Brown to testify about the lost earnings from each of his particular employers separately, I was able to use that testimony in order to fill up a lost earnings chart for the jury. So let's go to the blank lost earnings chart. And you see the difference here from the cost of treatment chart is that we have to provide for 3 different employers. We have to provide for the lost earnings in each period from each of 3 different employers. So first, James Brown testified about the time that he lost after the beating while he was undergoing psychological therapy. And after we testified, and his testimony is in the record and it's evidence in the case, at that point I signal my assistant and he inserts row number 1, which the jury can digest. There's nothing really complicated about that row number 1. Then James Brown testified about the 2nd period of time that he lost. And that's evidence in the record, and I signal my assistant to insert row number 2. And once again, that's in a form that the jury can digest. Everything is plain and simple to understand. I hope, I think, anyway. And I believe that the jury did understand it very well. And without being condescending, I feel that the only way they could assimilate these figures is by spoon-feeding it to them, because there was so much of it, so many different numbers coming from so many different sources, that's the only way they could really handle it in an intelligent fashion. And I'll go back to that phrase again, spoon-feeding it to them, and I think that PowerPoint was the best way of doing it. So the testimony of James Brown continued, and he told about the 3rd period of lost earnings. And you can see that Cambridge is in there again. And of course, the jury sees it. It's all very clear, I believe. And then we go to the fourth period of lost earnings. And this time, the two employers are MTA and Bound Business Solutions. Bound has replaced Cambridge, but it's simple. That's all very simple to see on the screen. And then we come to the last item. Well, oaths. Let me stop. You may be wondering what this oaths means, this oath procedure means, because it differs from the arthroscopies that he's been having up to that point. Now, firstly, I'll tell you what oaths is, but don't ask me any more about it because it's a medical term. An oath procedure is osteoarticular transfer system. That's where they get the abbreviation oaths. Osteoarticular transfer system. And the reason they use that on James Brown is because the two arthroscopies had failed. The injury to his knee was too severe to be healed by an arthroscopy. So they had to turn to something that was more complicated, and they felt would give him more of a likelihood of success, and that was the oath procedure. But unfortunately, and you see he was out for the oath procedure for a longer time than he was out for the arthroscopy. Okay, he was out for the oath procedure for a period of 5 months, and you see the two amounts of lost earnings, one for each employer. Unfortunately, that was not sufficient either, so he went for a third arthroscopy to Dr. Harwin, and those are the figures for the third arthroscopy. Then we added all the costs together and came up with a total figure. All right, there you are. So this chart that I think was indigestible when you first saw it, or maybe incomprehensible is a better word for it, is, I think, something that even the layperson, that any layperson can understand and follow when you give it to them in a bit-by-bit form. Give it to them row by row with PowerPoint. And then they see the whole story up there on the screen. All right, now you've seen how PowerPoint allows a trial lawyer to control the steady flow of information on a big screen to the jury. For an encore, you simply bring the full screen back and talk to the jury about it during summation. It's not only this screen, but also the cost of treatment screen. You can bring them both back during your summation in order to emphasize what they mean and the figures that are present in them. And the benefit of that is that the jurors know exactly where those figures came from. All right, now the other important witness, a vital witness for damages that we had for James Brown, was Dr. Harwin, who was the doctor who performed the third arthroscopy on James Brown. And Dr. Harwin gave his findings about injuries to the knee. And he gave us photos that he took during his arthroscopy, that we could use to enhance his testimony. He called those photos, we'll get to them, he called those photos intraoperative photos. And he used them along with his x-rays to explain, one, how the injury occurred. By explaining how the injury occurred means he had to state his opinion that the injury to James Brown's knee was consistent with James Brown's testimony about the beating that he took, the position that he was in, and the pressure that was on his knee during the time that the police officer was administering the beating. So Dr. Harwin had to testify that the injury that he found to James Brown's knee was consistent to that kind, was consistent with that kind of beating that was applied to James Brown. And he also, Dr. Harwin also would testify about how it affected James Brown, meaning how it limited his movements, how it forced him to reduce the nature of his activities and what he could do at work, and how many different kind of jobs he could perform. James Brown was, by the way, was an avid cyclist before this injury occurred. He used to even enter into these cycling tournaments and travel upstate. And there was even one tournament whereby the bikers, by that I mean bicycle riders, traveled all around the boroughs, the 5 boroughs of New York. I think starting in Manhattan and going through the various other boroughs, maybe except for the Bronx, and then coming back to the starting point. And James Brown had been very active doing that kind of thing. But this put a stop to it. This injury to his knee put a complete stop to any activity like that. He could no longer ride the bicycle and not compete in bicycle tournaments, but he couldn't even ride the bicycle. Now I'm going to show you the, oh, and one other thing that Dr. Harwin testified about is how the injury would affect James Brown in the future. And here I'm going to take a detour and go back to that treatment chart, the course of treatment chart, because when Dr. Harwin testified, he told the jury that James Brown, because James Brown was still not restored, far from restored to his normal physical condition, that James Brown would probably continue to suffer pain and discomfort, and they would probably need a knee replacement in the future. That's in the province of the medical expert. A lay plaintiff can't go predicting what kind of treatment he's going to need in the future. Of course, the court won't allow it. The lay plaintiff is not qualified to give testimony on that subject. So Dr. Harwin could testify that in his opinion, James Brown would need a knee replacement. He could and did testify to that effect. So at that point, we went back to this chart and we took out the total figure, that bottom line there, and we inserted a new row for the knee replacement. Because now it was in evidence by virtue of Dr. Harwin's testimony, and this gave us a new total figure increased by another $50,000. And once again, this was no mystery to the jury, because they see where all the figures come from, step by step, bit by bit, line by line. And you can't make it any simpler than that when you have to deal with all these different figures. So, now continuing with Dr. Harwin's testimony. I told you that he gave us x-rays and photos of an intraoperative procedure. Of course, we were projecting it up on a big screen instead of having Dr. Harwin holding up a slide or putting a piece of pasteboard up on an easel and pointing to it right then and there, which is not so easy to see for the jury. It's much better for visual purposes when the jury can look at the x-rays on a big screen and Dr. Harwin can stand there, use a clicker, and describe with the clicker what each x-ray signifies. Now, the other important part, and the most important part, I think, of Dr. Harwin's testimony was the intraoperative photos. He gave us a series of intraoperative photos that he took while he was performing the third arthroscopy on James Brown. Put that up on the screen now. I think that I was blazing a new trail with this because I had never seen anything like it presented before in a trial. Photos of a medical procedure taken during the various stages of a medical procedure or really during surgery. And of course, they seem mysterious. They seem mysterious at first glance. But the doctor used the PowerPoint slide on the big screen to explain them clearly. He the big screen effect gave his testimony and explanation the impact of a lecture to the jury. He became, in their eyes, much more than just a medical witness. Much more than just a medical witness. Of course, if the plaintiff can present a medical witness, so can a defendant. And the defendant did, in fact, present medical witnesses, trying to detract from all of the testimony that our witnesses gave. But the advantage that we had with Dr. Harwin was that he could adopt the status of a lecturer by using these photos on the big screen and trying to explain, or going on to explain to the jury in terms that they can understand exactly what was going on during the arthroscopy, what all these various photos meant. And let me tell you, the jury was really glued to his testimony at that point. And in fact, the defendant's lawyer got so absorbed in it that he went into the jury box and sat down and made sure that he listens to every word. That gave Dr. Harwin special status with the jury because of the way that he could put his testimony across in the form of a lecture, which none of the defendant's medical experts could do. Incidentally, going back to the way pasteboards were used before the advent of computers and PowerPoints, if we wanted to show these intraoperative photos in the pre-computer age, we would of course put it on a pasteboard as we did, and then put it on an easel, all right? And then Dr. Harwin would have to stand there and say, this means this, and this means that, and this means the other thing. But you can tell that no pasteboard exhibit can come close to making the impression or the impact that Dr. Harwin can make, or any witness can make, by using the big screen and a clicker like this to explain everything clearly to the jury. Once again, this is the way jurors today are used to processing information, coming off of a screen, the big screen TV that they have home or the screen in their computer. That's how they're used to getting information, and that makes them feel comfortable with getting the information, and it makes the information more credible to them, okay? By the way, this thing was marked after Dr. Harwin testified. We did have this pasteboard marked as an exhibit because jurors can't take the big screen into the jury room when they're deliberating. The best thing you can do in that regard is to make a pasteboard version, pasteboard facsimile, of each item that goes into testimony after you show it on the big screen, and then have it available to the jurors for their deliberation, so that when they go into the jury room and they're going to deliberate, that they can call for all of the exhibits that went into evidence and that they can review them again in the jury room. But it's still not as effective as showing it to them on the big screen to begin with. So now we've gone through all of the major elements of testimony in the case. The presentation of items that are usually considered dry and hard to remember take a different form when you use PowerPoint, because as you have seen, you can adjust and create and shape. You can shape the facts to make the maximum impact in the jury by making the dry numbers seem understandable and put them in the proper frame of reference. Now, there's another value to these charts, which I overlooked, but which I didn't overlook, but I skipped. But I think I should mention it to you now. seeing them now after you realize how they've been constructed, I think makes a lot of sense. One thing that's important is the consistency between the two charts. You'll notice that the first procedure here occurred on 12/22/2000, and the period of lost time and lost earnings resulting from that procedure also started on 12/22/00. Same thing for each procedure in the cost of treatment chart and each period of lost earnings. 1025, 1025, 227.04, 227.04, 1117.06, 1117.06. So this consistency really reinforces the claims that you're making to the jury, or really the evidence that you're presenting to the jury, and it prevents the adversary from pointing out discrepancies to the jury, which is something that an adversary will pounce on because that's part of their job. That's part of their job. In fact, trials have been described in many ways, but one way that I think is a fair metaphor is that the plaintiff's attorney is trying to build a house with proof. And the defendant's attorney is trying to tear it down by punching holes in the proof. And I think that's a very good shorthand way of seeing the different functions of a plaintiff's lawyer and a defendant's lawyer in a personal injury trial. So you want to be sure that there are no holes there that your adversary can find in the proof that you present. And the way to do that is to make sure that your proof is consistent. Consistent. That's a very, very important word. And just to show you how important it is, I want to go back to someone else in history, a great literary figure in history, named William Shakespeare, who also had something to say about consistency. Any Shakespearean scholars here who can tell us what William Shakespeare had to say? No. All right, how about an English lit major? No? Put it up on the screen. All right, I hope that convinces you. Now, once we've presented all our proof in a consistent manner, and there's no holes in the proof, we've reached the stage of the summation. And for the plaintiff has an advantage. The plaintiff always goes last. And naturally, for my summation, I relied for my summation on the subject of damages, not on liability. Liability was, of course, a matter of credibility. Is the jury going to believe James Brown, or is the jury going to believe the cop? By the way, we never found out because the case was settled before the verdict. But I'll get to that also. So, in order to reacquaint the jury with the strongest parts of our case, I presented the charts again during my summation. Let's go to the charts. Now at this point, when I came to summation, all of the facts and figures were in the record and had been portrayed to the jury on these charts in the rows that I had put up on the screen. So all I had to do was to tell signal my assistant to play the PowerPoint program again without having to add anything else. Go ahead. Good. And then I did the same thing for the lost earnings chart. Played it all over again for the jury right from the beginning. In that way, I showed the amount of damages that we were seeking in a linear and logical way. Once again, the jury sees a series of systematic and precise entries that culminate with the bottom line. That's almost a magical phrase, the bottom line, okay? That made the amount of each claim seem inarguable, you know, like a scientific result instead of a lawyer's hyped up number. You know, of course, I had pasteboard replicas of both charts, and I've shown you what pasteboards are like. And I had them marked into evidence so that I added big chunks of visual evidence that the jury could take into the jury room with them. And it would be useful to them because they knew how all these numbers were arrived at and what they meant and where they belonged. So using the big screen as I did from start to finish made me seem like a lecturer too. And think of how that serves to increase the credibility of a trial lawyer. You're more than an advocate, you're a lecturer. Because in the jury's mind, you're really teaching them something. In this case, a case that started out with an initial settlement offer of $10,000. That's what the city offered at the beginning. And it was offered as nuisance value. It was ultimately settled after summations and prior to the verdict for $550,000, a little over $500,000. And as a matter of fact, New York Magazine cited this case as the second highest recovery for an intentional tort case during the period of its survey. All right, so now you've seen how the modern use of graphics can add to the impact of your proof at trial. PowerPoint is the latest and best means for the presentation of graphics, the latest and best means that I have found. And using it in conjunction with the big screen, which is now available in all New York City courts, puts your case on a virtual pedestal right in front of the juror's eyes. If you realize that I was reading from something just now, I was, but I feel justified because I was only reading from my article in the Practical Lawyer. So that tells you about the value of using graphics as evidence during a trial. Thank you for your attention.